My mother said, "Who cares whose name was on it?" twice. The first time was in the kitchen of my parents' house on a Sunday in March. The second time was in the same kitchen 10 minutes later, after I had asked her to repeat what she had just said. She had not been embarrassed by the question. She had said it again with the same shrug, the same small dismissive lift of her right shoulder, the same casual tone she had been using on me about money my whole life. The money in question had been $94,000. The money had been the inheritance my paternal grandmother Wilhelmina had left me when she had died 18 months earlier. The inheritance had been specifically left to me, in her will, in a clause that had named me as the sole beneficiary, with my brother Alexei explicitly not included in the bequest. My grandmother had been clear about her reasons. She had told my father, in writing, that she had been concerned about Alexei's pattern of gambling and that she had not wanted to leave any portion of her estate to be lost at a casino in Atlantic City. The money had been transferred to a small estate account that my father had been managing as the executor. My father had then, over the following 16 months, drained the account in 11 small wire transfers into my brother's checking account, in a pattern that had been designed to look like a series of family loans, but that had in fact been the total liquidation of an inheritance that had not been my father's to liquidate. I had found out 4 months ago, when I had finally requested a statement from the estate account in my own name as the named beneficiary. The bank had sent it. The balance had been $412. The transfer history had been the 11 wires. I had driven to my parents' house that Sunday in March. I had asked my mother what had happened to the money. She had told me, in the small, careful voice she had been using my whole life, that the family had decided to use the money to help Alexei with some difficulty he had been having. I had asked her who in the family had made the decision. She had told me she and my father had. I had asked her whether they had been aware that the money had been left specifically to me, not to the family. She had been quiet for a moment. She had then said, "Saskia, it is family money. Who cares whose name was on it?" I had asked her to repeat what she had just said. She had said it again. "I want to tell you what I did over the next 4 months. I want to tell you what was on the small piece of paper the federal investigator had handed my mother at our kitchen table, and what he had said when she had looked at it. I want to tell you because there are people listening to this who have a family member who has done something to them that the rest of the family has decided to dismiss, and who have been weighing whether to dismiss it themselves, and who have not yet figured out what their options actually are. I want to tell you what mine were. Before I do, hit subscribe, and tell me one thing in the comments. Tell me about a time somebody in your family used the phrase, family money, to justify taking something that was specifically yours. Tell me how old you were. Tell me what you did with the phrase after they used it. I read every comment. Now let me take you back to my grandmother Wilhelmina, because the rest of this story does not work without her. My name is Saskia Bukowski. I am 34 years old. I am a compliance officer at a small investment firm in Boston. My job is to monitor financial transactions for patterns that suggest fraud, money laundering, or other forms of misconduct. I file regulatory reports with the federal government when I see things that are required to be reported. I have been doing this job for 9 years. I am the kind of compliance officer who has filed in my career over 300 suspicious activity reports with the Treasury Department's Financial Crimes Enforcement Network, which is called FinCEN by everybody in my industry. My parents had not known what my job actually was. I want you to understand this. My parents had known I worked in finance. My parents had assumed I was a financial advisor, like a slightly more boring version of my father, who had been a financial planner for 36 years. My parents had not been listening when I had explained, several times over the years, what compliance work actually involved. The not listening had been part of a pattern in my family that had been going on for as long as I had been an adult. I had been the daughter who had been doing serious technical work that nobody at the dinner table had been able to discuss with me. And so the family had simply stopped trying to discuss it. The not knowing was about to become the central fact of what happened next. My grandmother Wilhelmina had been a careful woman. She had been 91 when she had died. She had been the kind of grandmother who had paid attention to people. She had paid particular attention to me. She had also, in the last 6 years of her life, paid particular attention to my brother Alexei, who she had loved very much, but who she had figured out had been gambling beyond his means. She had told me about her plan 2 years before she had died, on a Saturday afternoon when I had been visiting her at the small assisted living facility she had moved into. She had said, "Saskia, I am leaving you $94,000 when I am gone. I am not leaving anything to your brother. I want you to know in advance. I want you to be ready. Your parents are going to try to redirect the money to him after I am dead. They are not going to be able to help themselves. You are going to have to be prepared to protect what I am giving you." I had told her I would. I had not, at the time, fully understood how serious she had been being. I had thought she had been exaggerating. I had been 32. I had not yet seen what families like mine were capable of doing once the older generation was no longer present to enforce its wishes. She had died 14 months later. My father had been the executor. My father had not given me a copy of the will despite my asking for one twice. My father had told me both times that there was no rush, and that the estate would be settled in due course, and that I should not worry about it. I had let it go for a few months. I had been busy at work. I had been getting married to my husband Anselm at the time. I had been distracted. I had assumed my father would handle the estate properly, the way executors are supposed to handle estates. I had finally requested the account statement myself, 14 months after my grandmother had died, because something at the back of my mind had been bothering me about the silence around the estate. The bothering had been the small professional instinct that compliance officers develop after years of looking at financial records. Something had not been adding up. I had not known what. I had been wanting to look at the numbers myself. The numbers had told me what I needed to know within about 3 minutes of opening the statement. I had driven to my parents' house that Sunday. I had asked my mother. She had told me what I have already told you. I had then driven home. I had been quiet for the rest of the day. I had been thinking about what to do. I want to tell you what I had figured out by the following Friday, because the figuring out had been the foundation of everything that happened next. I had figured out that my father had committed a specific form of fraud known as breach of fiduciary duty. As the executor of my grandmother's estate, my father had been legally required to distribute the assets to the named beneficiaries. He had not done so. He had instead diverted the assets to my brother. The diversion had been documented, in the 11 wire transfers, in a way that could be reviewed by any forensic accountant who looked at the records. I had also figured out something else, which had been the part that had taken me longer to see, and which had been the part that had eventually made everything bigger than I had initially understood. The wire transfers had been going to my brother's checking account. I had asked my mother, casually during the Sunday conversation, what Alexi had been using the money for. She had told me, in a small dismissive way, that Alexi had been paying off some old debts. She had told me she did not know the specifics. She had told me my father had been handling it directly with Alexi. I had thought about this for a few days. I had then, on the Thursday after the visit, used my professional access at work to do a small piece of research that compliance officers are allowed to do on individuals when there is a legitimate concern about financial misconduct. I had not been able to look at my brother's specific accounts because that would have been improper. I had been able, however, to look at general patterns of activity associated with his name across publicly available databases that compliance professionals use. I had found something. My brother had been the subject of 3 small civil judgments over the previous 2 years, in 3 different states, for unpaid debts related to gambling. The judgments had totaled approximately $43,000. The amount was significantly less than the $94,000 my father had wired to him. I had wondered, sitting at my desk that Thursday afternoon, where the rest of the money had gone. I had decided to find out. I had spent the next 3 weeks doing a small, careful investigation in my own time, using only legal methods that any private citizen could use, in addition to a small amount of professional knowledge about how to read patterns. I had subpoenaed nothing. I had hired nothing. I had simply looked at the publicly available records, had cross-referenced them against the information I had been able to gather from my own family, and had been patient about the picture coming together. The picture had been this. My brother Alexi had not just been using the inheritance to pay off old gambling debts. My brother had been using a portion of the inheritance to fund an ongoing pattern of activity that had included regular wire transfers, totaling about $30,000 over the past year, to a series of accounts in 3 different states. The accounts had been associated with a small group of individuals who had been, by the small details I had been able to piece together, intermediaries in a money laundering operation related to online sports gambling. My brother had not just been a gambler. My brother had been, in a small way, a participant in an illegal financial operation. My brother had been, in a more specific way, the kind of participant who is sometimes used by larger operations to move money through small personal accounts that do not trigger the same level of regulatory scrutiny as commercial accounts. The pattern was a known one in my industry. I had seen versions of it many times in my professional work. I had not expected to see it in my own family. I had been certain enough about what I was seeing by the end of the 3rd week to know that I had a professional obligation. As a compliance officer, I was required by law to report suspected money laundering when I had reasonable basis to believe it had been occurring. The obligation was independent of who the suspected launderer was. The obligation applied even if the launderer was my brother. I had filed a suspicious activity report through my employer's regulatory channels on the appropriate FinCEN form, 4 weeks after my visit to my parents' house. The report had described the pattern I had identified. The report had named my brother. The report had also named my parents as the apparent source of the funds being moved through my brother's account, although I had not at the time been certain whether my parents had known what Alexi had been doing with the money or whether they had simply been negligent. I had filed the report on a Monday. I had then waited. I want to tell you what happened over the next 3 months. The suspicious activity report had been reviewed by FinCEN within several weeks. FinCEN had referred the matter to the FBI's Boston field office, which had jurisdiction over the relevant financial institutions. The FBI had opened a formal investigation. The investigation had been thorough. The investigators had subpoenaed bank records, communication records, and various other documents that were beyond the scope of what I had been able to gather on my own. The investigation had confirmed what I had suspected, and had also revealed additional details I had not been able to see from my limited vantage point. My brother had been moving money through his personal accounts on behalf of a small, organized betting operation that had been based in southern New Jersey. The operation had been small but established. Alexi had been one of about a dozen individuals being used by the operation to move funds. He had been receiving a small percentage of the funds he had moved, which had been roughly $7,000 over the past year. The investigators had also discovered that my father had known. My father had known for at least the past 8 months. My father had been told by Alexi sometime in the previous summer that the gambling debts had not been the whole story, and that Alexi had been involved in something more complicated. My father had not been part of the operation itself. My father had, however, continued to wire money to Alexi after being told, in the small, careful way some parents continue to enable adult children, even after they realize the enabling is funding something serious. My father had been, in legal terms, willfully ignorant about the destination of the funds he had been wiring. The willful ignorance had been the part that had made him potentially culpable, not just for the breach of fiduciary duty regarding my grandmother's estate, but for a related charge regarding the funding of an illegal operation. The investigators had moved quickly once they had assembled the picture. On a Friday morning in July, exactly 4 months after my Sunday visit to my parents' house, the federal investigators had executed a series of coordinated actions. The bank had frozen every account associated with my parents and my brother. The FBI had served subpoenas at 3 locations. A federal agent named Mr. Wendell Halpern had been sent to my parents' house to interview them. I had not been notified in advance about the timing of the interview. I had been at work that Friday morning. I had received a phone call from my mother at 11:42 in the morning. My mother had been crying. My mother had told me that an FBI agent had been sitting at our kitchen table. My mother had told me he had been asking her questions she had not known how to answer. My mother had told me that all of their accounts had been frozen that morning. My mother had told me, in the small, breaking voice I had not heard her use in my whole adult life, that she had not known what to do. I had not gone to the house. I had told my mother that I could not advise her, that she would need to retain a lawyer, and that I would be available to talk to her after she had done so. I had hung up the phone. I had then, in the small, careful way I had been making decisions for the previous 4 months, called my own lawyer to make sure my position was protected. My lawyer was a small, careful woman named Ms. Halia Voronova, who had been my lawyer for the previous 3 years for routine matters, and who had been advising me, since the filing of the suspicious activity report, about how to handle the family fallout. She had told me that morning that I had done exactly what my professional obligation had required, that I had no legal exposure, and that I should continue to be polite but distant with my family until the investigation had concluded. I had been polite but distant for the next several weeks. I had received about 30 phone calls from various family members. I had returned a small number of them. I had been clear, in each conversation, that I had done what I had been legally obligated to do, that I could not discuss the investigation, and that I was sorry for the disruption to the family. I want to tell you what the federal investigator had said at my parents' kitchen table, because my mother had eventually told me, 3 weeks later in a difficult phone call, what had happened during the interview. Mr. Halpern had sat down at the kitchen table. My mother had offered him coffee. He had declined. He had told her that he was there to ask her some questions about a federal investigation involving her son Alexi and her husband Bram. He had told her she had the right to have a lawyer present. He had told her she could decline to answer questions if she chose to. He had told her that anything she said could be used in the course of the investigation. My mother had agreed to talk to him. My father had also been at the kitchen table. The two of them had answered Mr. Halpern's questions for about 2 hours. Toward the end of the interview, Mr. Halpern had asked my mother whether she had known the source of the funds that had been wired to Alexei over the previous 16 months. My mother had told him, in the small, careful voice she had been using my whole life, that the funds had been family money. Mr. Halpern had been quiet for a moment. He had then said, in the calm professional voice federal investigators use when they are about to deliver a piece of information that they have been holding back. Mrs. Bukowski, the funds were not family money. The funds were a specific bequest from your husband's mother to your daughter Saskia. I have a copy of the will here. Your husband, as executor, had a legal duty to transfer those funds to Saskia. He did not. He transferred them to your son. The funds, while in your son's account, were then used to facilitate the laundering of money from an illegal gambling operation. Your daughter Saskia filed the suspicious activity report that initiated this investigation. She did so because she had a legal obligation as a compliance officer at her firm. She did not have a choice. I want you to understand that. Your daughter did not betray your family. Your daughter performed a legal obligation that protected her from criminal liability and that exposed an existing crime. The crime is not hers. The crime is your husband's and your son's. I am asking you, as a courtesy, to please not blame your daughter for what is about to happen to your family. The blaming would be misdirected. The correct direction for your concern, going forward, is your husband and your son. Do you understand? My mother had not been able to respond for a long moment. She had then said, in the small voice my mother sometimes uses when she has been confronted with something she had not been ready to be confronted with, "Yes, I understand." Mr. Halpern had stood up. He had thanked her for her time. He had given her his card. He had told her she should contact her attorney as soon as possible. He had walked out of the house. My father had been arrested 2 weeks later on charges of breach of fiduciary duty and wire fraud related to the estate. My brother Alexei had been arrested 3 weeks after that on charges of money laundering and conspiracy. My mother had not been arrested. She had not been a party to the underlying crimes. She had been, however, a witness, and she had been required to provide testimony in support of the prosecution. I want to tell you what has happened in the 7 months since the kitchen table interview. My father pleaded guilty to the lesser of the 2 charges in exchange for testifying against the gambling operation. He was sentenced to 18 months in federal prison. He has been at a low-security facility in western Massachusetts. He will be released in approximately 10 months. His sentence will be followed by 3 years of supervised release and a requirement to pay restitution to my grandmother's estate, which the court has ordered to be paid to me as the named beneficiary. My brother Alexei pleaded guilty to the money laundering charges. He was sentenced to 46 months in federal prison. He is at a different low-security facility in southern New Jersey. His sentence will be followed by 3 years of supervised release. He has not been authorized to contact me directly. My mother has been alone in the house. She has been struggling. She has been calling me irregularly in a pattern that has been part apology and part request for assistance. I have been responding cautiously. I have been clear that I am willing to be in a relationship with her going forward, but only on terms that do not involve me providing financial or emotional resources to her in a way that would be enabling. She has been understanding this slowly. The understanding has not been easy for her. My grandmother's inheritance is in the process of being restored. The court has ordered the restitution to be paid over the next 12 years, in monthly installments, from my father's retirement assets and from the future earnings of my brother once he is released. The full restoration will take time. The slow restoration has been acceptable to me. The slow restoration has been more important in the end than the speed. The principle has been the thing. My grandmother Wilhelmina had been right when she had told me 2 years before her death that I would need to be ready to protect what she had been giving me. She had been more right than I had understood at the time. I have been thinking about her almost every day since the kitchen table interview. I have been wishing I could tell her what happened. I have been hoping, in the small way you hope about people who are no longer here, that she would be proud of what I did with what she had given me. I want to tell you what I have learned. I have been thinking about it for 7 months, and I want to give it to you carefully. The first thing I have learned is that the phrase, family money, is sometimes used to disguise specific theft of specific assets from specific individuals. The phrase has a useful softening effect. The phrase makes a discrete legal violation sound like a casual family accounting decision. The phrase is, in many cases, the linguistic tool that families use to make the unfavored member of the family feel unreasonable for asking what happened to what was specifically hers. If somebody in your family ever uses the phrase, family money, to describe an asset that was named for you specifically, please understand that the phrase is a tool. The tool has been designed to make you back down. The tool has been refined, in your family, over years of practice. The tool will not work on you unless you let it. The not letting is the choice that protects you. The choice is yours alone. Nobody else in your family will make it for you. The making of it is what separates the people who will recover what was theirs from the people who will spend the rest of their lives wondering what happened to their inheritance. The second thing I have learned is that the professional obligations you carry in your work life sometimes turn out to be useful tools in your family life. I had been a compliance officer for 9 years before the inheritance was stolen. I had spent those 9 years learning in extensive technical detail how money was laundered, how fraud was detected, and how regulatory bodies investigated financial misconduct. The training had not been intended to be useful in my family. The training had been, however, exactly what was needed when my family had finally given me a reason to apply it. The exact useful skill, when the moment arrived, had been mine to deploy. If you have professional skills that could be useful to your family in a crisis, please consider that the skills are part of who you are. The skills do not stop being yours when you walk into your parents' house. The skills are available to you. The using of them is appropriate when the situation calls for it. The not using of them is, in many cases, the small, careful avoidance that protects your family from the consequences they have earned. The protecting of your family from consequences is not always the kind of love your family deserves. Sometimes the consequences are what makes the love eventually possible. The deploying of the skills is the gift you have been carrying without knowing it was a gift. The recognizing of the gift is what changes everything. The third thing I have learned, and the last one I want to give to you, is that the people in your family who have been protecting the wrongdoer from consequences for years are not always doing it out of love for the wrongdoer. They are sometimes doing it out of a deeper fear of having to look at what their family actually is. My mother had been protecting my brother for over a decade. My mother had told herself the whole time that she had been doing it because she had loved him. My mother had been, in fact, doing it because the alternative would have required her to acknowledge that her family had been the kind of family that had produced a son who would gamble away his sister's inheritance and move money for an illegal operation. The acknowledging would have been too painful. The protecting had been easier. The protecting had also, over the years, made the underlying problem worse. By the time my brother had been arrested, my brother had been 12 years into a pattern that should have been confronted by my parents at the start, when the consequences would have been smaller and the recovery would have been more possible. The protecting had not been love. The protecting had been a small, careful avoidance of grief. The grief had been my mother's to feel, not my brother's to be spared from. The mixing up of those two things had been the engine of the entire situation. If somebody in your family has been protecting another family member from consequences for years, please consider that the protecting may not be about love. The protecting may be about the protector's own fear of grief. The grief is theirs. The consequences are the wrongdoers. The two things have to be separated. The separation is sometimes done by the third family member who is willing to do the hard thing that makes the protecting impossible. The hard thing is rarely thanked in the moment. The hard thing is, however, sometimes the thing that gives the protector the permission to finally feel the grief they have been avoiding for years, which is the foundation of any actual healing that ever happens in the family. The healing was never going to come from continued protection. The healing was always going to come from consequences. You can be the person who delivers the consequences. The delivery is not love against your family. The delivery is the precondition of love eventually being possible in your family, if love is ever going to be possible at all. I want to ask you something before you go. Tell me in the comments about a phrase your family has used to disguise a specific wrong against you. Tell me what the phrase was. Tell me what the wrong was. Tell me whether you eventually figured out that the phrase was a tool, and what you did with the figuring out. There are more of us than the families who have been using these phrases would ever guess. We have been recognizing the tools for what they are, slowly, over years, and we have been deciding what to do with our recognition. Tell me yours. I will be reading every single comment. I will see you in the next one.